right, welcome everyone to the estate planning workshop presentation for this month. My name is Troy Moore. I'm going to get things started for everybody. Let me just get the PowerPoint presentation going. Like I said, thank you for coming. This is the estate planning workshop. I will be the one presenting it. The two ladies in the background are my two awesome paralegals, Tiffany Bell and Andrea Patino. They help with everything I do around here. For the next 30 minutes, I want to share with you what you might not know about estate planning. So tell me, raise your hand if you currently have an estate plan. A lot of people don't, some people do. A lot of you that do have an estate plan, it's going to end up in probate court, which is, as you'll find out, a place you don't want to end up anymore. So what are some doubts that people have about estate planning? The three biggest doubts that I hear about estate planning is that somehow planning for death will hasten its occurrence, or that it will take too long, or they don't have enough time. I also hear that, well, I'm not old enough to do that yet, or I don't have enough money for that. All of those are not true. The good news is I've never had a client pass away immediately after signing their estate plan, and you really do owe it to your loved ones to make sure they are protected. All of these documents and all of these things you're doing, you're not doing them for yourself per se. You're actually doing them for the people that come in and clean up after you and take care of things for you. And the good news, the third one, is that the benefits of estate planning are not tied to age, wealth, parental, or marital status. What you're going to learn today is how to name guardians for your minor children, how to avoid probate court, your estate planning options, what's the difference between a will and a trust, and how to protect your children's inheritance. This is me. My name is Troy Moore. My office is on Highway 249 at the Chasewood Park exit. It's very close to Vintage Park. There's my email and phone number. I have been licensed since November of 2001 by the Texas State Bar. I'm an Aggie and a graduate of South Texas College of Law. I went out on my own as a solo practitioner in 2008. And I've been out on my own since then for over 15 years. Please check my online reputation out. I'm very proud of my 63 Google reviews that are all 5 stars, and most of them are dealing with estate planning and probate issues in particular. Well, part of getting your own affairs in order, we're going to talk about how to do that. The first part is how to start your own estate plan. We'll talk about what's involved, and then, of course, we'll talk about how much it costs. So what is your estate plan? You might think you don't have one, but you do. It's just that Texas has written it for you. Estate planning is opting out of the default plan for your family and assets. Here's what happens if you die without a will in Texas. This is the law of descent and distribution, also known as the legal effect of not having a will. Depending on whether you're married or had children with somebody else and are now married to somebody else other than the mother of those children, things can vary wildly as far as who gets what. And in particular, a second spouse in a blended family gets treated very poorly with the community property real estate, as you'll see a little bit later. Goals of estate planning are, people have different goals, but some of them have all of these. But you want to give what you have to whom you want, the way you want, when you want. Avoiding probate court is important because it's very expensive nowadays. You want to maximize the assets that are distributed to your loved ones and also care for yourself during your lifetime. We do that through powers of attorney. We can fulfill your charitable intentions through your will or your trust, through any giving that you want to have take place. We can help minimize taxes due at your death, help care for and protect others, such as your surviving spouse and children at death, and also estate planning helps to pass on your values and ideals to your children and grandchildren, and it protects your assets from creditors, divorce, bankruptcy for generations to come, potentially. So the downsides to dying intestate, and dying intestate just means that you never made a will before you died. The assets get distributed according to state law. You saw the pie chart earlier. Everything goes by genetics and marriage. It could go to people who you don't want having it. The kids get inheritance at 18 and outright, which could be lost in a divorce or just outright spent unwisely. A spouse could remarry after your death, leaving money to a new spouse and kids. That particular instance is prevented in the revocable living trust, as we'll talk about later. Potentially, if you die intestate, a judge could decide who raises your minor children if there's a fight over the family on who gets to raise your minor kids. A judge will also decide who's in control of your children's money. Probate court is guaranteed when you die intestate. And if there's minors, there's going to be a permanent guardianship proceeding over who has guardianship over the minors, which is very expensive, it's rigorous, complex, and lengthy. And sometimes in-laws can end up fighting over which grandparents are better to raise the babies. So the solution is we have married couples nominate guardians in their will. If it's a couple, we say what happens if they divorce or one of them dies. And we also nominate backups in case your first choice isn't available. Okay, so what about the money? What is an estate? Well, it's probably all the things you think. It's all your stuff: bank accounts, checking accounts, savings accounts, cars, boats, motorcycles, stocks, bonds, life insurance proceeds, houses, other real estate, lots, mineral interests, retirement accounts, IRAs, 401ks, annuities, coin collections, artwork, intellectual property such as trademarks or patents, and even your business interests. So the membership interests of your LLC or the shares of the C Corp that you own, all of those things are also part of your gross estate. Why is title so important? Well, the magic rule of title, the title equals the result. So in probate court, title is very important, and that's what we're doing, is transferring title from one person to another after somebody dies. The importance of title. There are 3 ways you can own property at the time of your death. One way is individually. This is how most people own things. Just think about if you go to the bank with $100 and open up a bank account in your own name. That's an individual titled asset. You can also hold an asset jointly. Common example of this is a joint bank account with a right of survivorship. Both account holders have 100% access to the account. After one of them passes away, though, probate isn't required for the person that died. There's an automatic right of survivorship in that checking account where the ownership automatically passes to the other account holder upon death. And that is a joint checking account with a right of survivorship. It can also be done, the importance of title can also be shown by contract. Property can be held by contract. Think like a life insurance or a 401k. You have a contract with that life insurance company to pay your designated beneficiary when you die, so long as you've paid the premiums. That is going to pass directly according to the contract and to the designated beneficiary that you designate within the contract. The risk with jointly held assets, the example I gave earlier was the joint checking account. It does avoid probate court when the first owner dies because there's an automatic right of survivorship to the other account holder. But you still have to go through probate when the second owner dies, or if they die at the same time. Beneficiary designations also have risk. A lot of times people put minors' names as beneficiary designations. It's a terrible idea. For beneficiary designations, they will only go to the named beneficiary if they're over the age of 18 and alive. If you put a minor's name down as a beneficiary, you're guaranteeing that the parents of that minor are going to have to open up a guardianship if you die before they turn 18. A lot of bills associated with that. And also with beneficiary designations, any payments that get made don't have any rules or any guardrails associated with anybody doing any kind of check on the spending by the beneficiary. It's going to just be money in a bank account that they can use as they see fit. So I see a lot of estate plans that fail up here when I'm doing probate consults or just reviewing people's documents to see if they would like to update them. But why most estate plans fail is poorly drafted documents that don't provide for any kind of avoidance of probate, and the documents are old and haven't been updated. They have people named that they don't even want serving anymore. They have property identified that they don't even have anymore. These things need to be updated every 3 to 5 years. You don't make one will and then use it until you die. Life changes, your property changes, the laws change. Everything needs to be updated 3 to 5 years. Another way estate plans fail is they're designed where children get the inheritance at 18, and it's also not protected from divorce, bankruptcy, or lawsuits. So last will and testament, while you do end up in probate court, it is better than nothing. It designates guardians for your children. It designates beneficiaries for the assets that you owned individually, and it designates an executor to wrap up your affairs. The downside to it is that you have to go to probate court. So what is probate court? Well, it's a lawsuit process. It's not just a matter of filing a form down there. It's a full-blown lawsuit with a hearing and post-trial measures. The first step, the court appoints an executor after an application gets filed. Then we have to publish a notice in the newspaper that is a notice to creditors to come forward and make a claim against the estate. The third step is to inventory the assets that were in the estate. That becomes a public record downtown that the judge signs off on. Then the next step is to distribute the assets. That is the executor's job. Everything is reported back to the judge. These are all public records that anybody can go pull a copy of downtown. Depending on the type of probate, you need court permission to do certain things. And lastly, you always have to hire a lawyer in probate court. Even lawyers that don't do probate have to hire probate court lawyers because it's just so different even to lawyers. So 3 downsides to probate: it's expensive, it's time consuming, and it's public. Right now, I charge almost $5,000 as a flat fee for doing a probate. That's even with a will. The public side of a probate is something that is distasteful to most people. The inventory that's in your estate, anyone can go down and look at a public record as to how many assets you had, who you gave it to, what you put in your will. There's other ways that things can happen more privately. Here's a common example of a probate estate where we have a family home with a fair market value of $400,000. We have a rental property, some stocks and bonds, and then look here, we have life insurance payable to a minor. Bad move. A 401k payable to a minor. Very bad move. You're guaranteeing a guardianship. We're guaranteeing a probate case for both husband and wife. You see at the bottom here, we have an intestate probate plus a guardianship, easily $40,000 and then some over the life of the minor children, because the guardianships aren't a one-time thing. The guardianships stay in place until the child turns 18. So when would a will-based plan be appropriate? Well, if you just want guardians for your minors and you don't care about the probate cost, in that case, probate avoidance is not the goal, so a will is sufficient and would be perfect for you. Well, so if a will isn't the answer for you, then what is? So here we'll talk about your options that I offer up at my office. The first option is the one that we've gone over, is the last will and testament. That's called my silver package. And then option 2 is the probate avoidance package, which I will go into more detail on in a moment. And then option 3 is the revocable living trust package. So option 1, you're going to end up in probate court. And with options 2 and 3, both of those packages are designed to keep your estate out of probate court and save at least $10,000 for a married couple between probate fees. So talking about the probate avoidance package a little more and breaking it down, what it is made of is a collection of documents that ultimately allow you to avoid probate. We do this with a combination of transfer on death deeds for real property. We have an acronym for those, is TODD, so we just call those TOD deeds. The probate avoidance package avoids the complexity of a will or a trust administration, which is very nice. It is really the easy button. Here, also with the probate avoidance package, the TOD, the transfer on death deed, it is revocable. You can change this or amend it. It's not set in stone once you do it. Just like a will, you can change your mind as life goes on. The probate avoidance package also includes doing powers of attorney, which everybody needs for medical and financial decisions before they pass away if you become incapacitated. Think Alzheimer's or traumatic injury where you're unable to take care of yourself. So we talked about what is a TOD anyway. Just a little further explanation. A TOD is a transfer on death deed, or TOD for short. It's just a specialized Texas deed that allows for non-testamentary transfers of real estate. And that just means real estate being transferred not through a will. Here's an example of where you would want to use a TOD deed. Bob has a $500,000 house. He has a son, Fred. He wants to leave it to his son, Fred, when he dies. This works for Bob because his kids are already grown and he wants true simplicity. You see the easy button there. Bob needs a probate avoidance package because after Bob is gone, the only thing Fred has to do is file a memorandum of death regarding the real property, and that gets filed in the real property records, and the title transfers automatically. There's no probate administration. There's no trust to read to figure out what needs to be done. It is truly the easy button. So the probate avoidance package works because most everything you own right now is a probate asset. And we reposition your assets between your real and your personal property to pass directly to your children through the Todd deed. You see JTWROS, that is short for joint tenancy with right of survivorship. Those are the joint checking accounts that you know of. And then there's TOD, POD, or beneficiary. TOD stands for transfer on death. POD stands for payable on death. TOD, POD, and beneficiary are all pretty much the same thing. It's the name on the line that gets the property after the owner has died. Looking at line 3 with the probate avoidance package, you still maintain control over all of your assets throughout your life. You can change your mind, you can change the beneficiary even. But the benefit is that everything you own bypasses probate when you pass away. That's $5,000 automatically for a single person if they have a will. It's about $8,000 to $9,000 if you don't have a will. And between a married couple, you have to probate the husband's will, then you have to probate the wife's will. So that's $10,000 that's saved just by using a probate avoidance package. For a lot of people, that's brand new information, and they didn't know that it was that easy to avoid probate court. So an even better option, if you need more options available to you, is to do a revocable living trust. Revocable living trusts are like wills on steroids. They name beneficiaries for your assets in the trust. The trust is revocable. You can change or amend it, just like your will, just like the Todd deed. And you're the trustee during your life. You have total control. If you're married, you and your spouse are the co-trustees together. Right now, everything you probably own is outside of your trust. What you do with the trust is you move your assets into the trust by retitling them into your trust. You remember earlier how we talked about how title controls everything. The nice part about the revocable living trust is that you retitle it into something else other than your name, but you still maintain control over the assets in the trust. And the benefit in the end is that everything in your trust bypasses probate when you pass away. The way it works is your trust names a backup trustee after you, and that backup trustee comes in and is able to sign for and transfer the property. So what is a trust anyway? Simply put, an agreement. A trust is just an agreement that spells out the rules that you want followed for the assets in the trust after you pass away. We'll go back to the example with the guy Bob, where a trust would work for him. Bob has a $500,000 homestead. He would like to leave it to his son, Fred, when he dies. But in this instance, Fred has not grown at this point, and he wants Fred to at least be 25 years old, and he wants him to have graduated college. Well, in that event, Bob's going to need a trust in order to have that extra administration and the extra control beyond death that's going to be required. And this would also, another common example where a revocable trust, it works better than a probate avoidance package, is if you have any rental properties that need to be managed after death. A revocable trust package versus a probate avoidance package is a better fit for anything where there's business interests that need to be managed or anything else that needs to happen after death other than title transfer. So there's 3 roles in every trust. There's the grantor, also known as the settlor. That's just the person who made the trust and provided the property for it. The trustee is the person who manages the trust assets, and the beneficiary is the person who's entitled to receive them. The best part about doing a revocable trust for a married couple is you're the grantors, you're the beneficiaries, and you're the trustees all at the same time. This gives you total control, and yet you still get to transfer everything outside of probate after you pass away. So a revocable trust is kind of like a kid's backpack. if you would think of it as that. So an empty backpack is bad. Anything that is not in the backpack is not going to avoid probate court. So we have all of the things that you put into the backpack, into your revocable trust is good because all of those items will flow through and avoid probate court totally. A trust solves all the problems that come with a will. It allows you to still manage things after death. You won't lose a good chunk of your estate in probate court. The assets go to your family in weeks and not years. Plus, it's totally private during life and at death. There is no register of trusts in Texas. You can't go look up somebody's trust like you can a corporation or a limited liability company. You don't find out about a trust unless you have business with a trust. And they're very private, and it's one thing that people like about generational transfer is the privacy that it provides through trusts. Other benefits of a revocable living trust: it is easily changed. They are valid in every state. You might want to tweak them if you move from state to state, but by and large, they will easily be applied state to state. They're difficult to attack because, as I alluded to earlier, they are private and you can't look them up. So you have to know about them and know who's in charge of them in order to attack them. The trust, revocable living trust on the bottom left here, it's not a separate tax identity. You can use your own social security number for all the accounts and all of the different things for it. They're not difficult to create and maintain, and it creates one backpack for all of your property. You can use this revocable living trust to do anything. You can treat it like your own little LLC. You can even have it form LLCs even. Okay, but what about guardians, which is always important? Even when we do a revocable living trust, we still do a pour-over will, which is just a special will that just says, I leave everything to my trust, and it pours everything over to the living trust. In that pour-over will is where we nominate your guardians for your minor children. So things parents worry about after they're gone: kids getting divorced, family assets going to strangers, kids losing their inheritance to creditors, or lawsuits for personal responsibility. The children's trust is good because it keeps it protected. A children's trust is like a tube of toothpaste. It holds the children's inheritance. Kids can squeeze money out when they need it, but what remains in the tube is protected from lawsuits, bankruptcy, and divorce. The revocable living trust contains a children's trust in it that is built just for them. You pick the trustee. It can be you or even your adult child or one of your other adult children. The children's trust protects your children's inheritance while still giving them access to it. So you just want to squeeze out a little bit of a time at a time from the trust, because after it comes out of the tube of toothpaste, it is fair game for creditors and everyone at that point. You might be wondering, are there any type of estate taxes I have to worry about? Not in Texas unless you have more than $26 million as a married couple. One of the things to think about is, what's your COD number? What is your cost of death? So if you die intestate probate, you can see in the first column for a married couple, that's at least about $15,000 as far as how much it's going to cost. Who's in control of the estate is out of your control, and the time is indefinite. The silver probate package, which is option one you saw, a married couple will end up spending at least $9,000 in probate, even if they have wills. The control is that they decide now, which is nice, and the time is quicker, which is 30 to 90 days, but you still have that big $9,000 price tag up top. The next level up on estate planning packages is the gold package, and that's the probate avoidance package. You can see that the cost of death is zero. The control you decide now, and the timing is immediate. Versus the last package, which is the revocable living trust package, the platinum package. Again, it avoids probate, so the cost of death is zero, and the control you decide now, of course. But the timing is, it depends, because we could have minor children, and their trust could last for a good while, like it should. If you're interested in the next steps and what do you need to do, how do you make it happen, when should you get things started, and all, most importantly, what's the investment to get it done, right? You might be thinking about doing DIY documents. I wouldn't recommend those. They may not comply with state law. There's no personalized planning, and it's cookie cutter design that are applied across the country. And Texas does have some magic language that needs to be in our documents. Regarding executor appointments, A lot of times the bare bones trust will end up not being funded at all or improperly funded, and you end up in probate court anyway. The whole objective is to stay out of probate court nowadays. And if you don't do things the right way, you're going to end up there no matter what. When you are working with an attorney, you're paying for the guidance and counseling about how the documents should be drafted, not just the documents themselves. Additional experience was hourly billing, reactive, and transaction-based. And at my office, we do things on a flat fee. We're more proactive and engaging with you, and we're more of a relationship-based law firm. We don't want to just do your estate planning one time and never see you again. We know that these documents need to work for you when you need them, and hopefully it's not for a long time. So timely updates are important. We want to stay in touch with you because you do need to update these as you change residences and change bank accounts and things like that in order to maintain avoiding probate. Our estate planning process is: one, you attend the workshop; two, the design meeting with me where we go over and design everything for your estate plan. And then we go back and draft all the documents, and then we schedule the signing meeting with you all where you come in to the office and we go over everything personally and then sign. So the three different packages: the silver package was the last will and testament package. That is $2,000 for the entire package, including all the powers of attorney and everything that come with it. The gold package is the probate avoidance package. That's $3,000. And these prices here are married couple prices. Take $500 off of each one of these prices, and that's what it is for a single person. And for the platinum package is the revocable living trust package with the children's trust. That is $3,500. And again, that's a married couple price. So those are the three packages, and what is in those you can see right here. We have the silver plan, the gold plan, and the platinum plan. They are, this is an itemized list of every document that is in each one of those packages. And I'll leave that there for a second. Okay, and at the design meeting, what we'll be doing, if you're married, we'll need both spouses to be there. We'll fill out your online family profile. We'll answer your questions, select the estate planning package, sign the engagement letter, collect the fee, and design your estate plan. Who we work with are people who have taken the time to attend the workshop so that they can make educated, informed decisions, and people that don't have a current estate plan or that want to update their estate plan. And we only work with people who are ready to get started with the process, not just talking about it. The ultimate objective up here is to position your assets to where they flow down on the right side of this page into the non-probate assets. Everything that flows into the non-probate assets bucket, you will not need a lawyer for. Here's the page that you're trying to stay off of. This is the page I show to people in my office when we're talking about your probate options. Depending on whether or not you had a will or no will, these are the different costs for the different services of probate that are required depending on how they died and who was in their family and how long it's been and different things. So if you want to get things started for your estate planning, we have an offer for $250 off any of those packages if you sign up today. So, but what if you're not ready for a full estate planning package and this is just so overwhelming that you've got to think about it? Well, there is also something that you probably don't know about called a survivorship agreement deed. And pretty much if you're a married couple and you own a house in Texas, your title is broken and you don't even know it. Chapter 112 contains section 112.051. This is in the Texas Estates Code, and this provision was only added back in 2009. What section 112.051 says is that at any time, spouses may agree between themselves that all or part of their community property becomes the property of the surviving spouse on the death of a spouse. Now, why is that important? Well, it's important because that's not the way things happen legally in real life normally. When somebody dies, you have to probate their estate to figure out who gets their property, is the general rule. Here, this new law says that in 2009, that married couples, when dealing with their community property, they can make an agreement that community property becomes the property of the surviving spouse on the death of the other one. This is new stuff, and it is rather big. Where we get to use it is in a survivorship agreement deed. You might recognize Mr. Deed here from his cousin, Mr. Bill, up on Capitol Hill. So a survivorship agreement deed uses that previous law that I just talked about, 112.051, and it inserts a survivorship agreement into a deed for your homestead residence, the community property. So, but what is a deed generally? A deed is just a legal instrument that transfers property rights from one person to another. Here, a survivorship agreement deed is a specialized deed where I add new language that is now legal and can be added to deeds that heretofore was not available to people. Things take forever in the legal world. That isn't that long ago. A survivorship agreement deed, just like any other deed, must be filed or recorded with the county and get a stamp. And you may be thinking to yourself, what is a survivorship agreement deed? Why is he talking about a survivorship agreement deed? Why would I even want one of these? Well, in legalese, it provides for a non-testamentary transfer of a right of survivorship agreement. Translation means that it creates a last man standing part on who gets the property. Think about like the joint checking account with a right of survivorship. It just automatically passes to whoever the other owner is. You don't have to go to probate court or do anything like that. This is what it does for your real property, your homestead, your community property. So what a survivorship deed prevents is the need for probate when the first spouse passes away. Probate needs to be done for each spouse in a married couple after they pass away. So if a house is owned by two people, you're going to have to do two probates in order to be able to sell that house. So each probate is going to cost from anywhere from $5,000 to $9,000. So the survivorship deed prevents the need for probate when the first spouse passes. What a survivorship deed does not do is transfer other assets such as vehicles or financial accounts. It doesn't create any tax implications for you. And most importantly, it does not provide for the transfer after the death of the surviving spouse. That's going to be taken care of in your other estate planning documents. So what are some common legal myths? We'll dispel one here today, that you're common law married after you live together for 7 years. Not true. What's another legal myth? Another one I hear all the time is your spouse automatically gets your home when you die. That's not true either, especially if you're in a blended family. Another one is every attorney does criminal law. I can't tell you how many times I've been at a party and somebody I've known my whole life has asked me, what's the craziest murder case you had? Or, everybody thinks that every attorney does criminal law. I think it's because of TV shows. I'm not sure. Or you could get your legal advice from this lady who gets hers from Law and Order. She probably listens to what they say. And in my office, I hear people tell me what they say all the time, which is bad legal advice. And they say a lot, and it's usually wrong. So regarding your home and how you think things go after you pass away, this is what you probably think happens. Husband marries wife, buys a house. Everything's great. Husband, like we always do, passes away first. And then you think it's automatically transferring to the wife, but it's not. What happens in real life is husband's got a couple kids from a prior marriage. Then he marries wife and they have a child together. They then buy this house just like before, but just like before, husband passes away. If husband didn't have a will, you see these arrows coming here, it's a mixed bag of who gets things from the husband. And if the current wife is not the mother of all of the husband's children, then that wife gets 0 of husband's interest in the community property house. 100% of the husband's ownership in the community property house passes to all of his children. This is when there's no will. This is a terrible instance for any surviving spouse, particularly if there's minor children. The solution: husband has kids from a prior marriage. They have one together with his second wife. They buy a house together. Husband and wife sign a survivorship deed which creates a survivorship agreement between the two of them to where if one of them passes away, title automatically passes to the other without probate court. Then husband passes away, the survivorship deed activates, wife becomes the 100% property owner. Don't have to deal with probate court or guardianship because of minor children being owners of real estate. The result, happy wife, happy life. With the surviving deed, or I'm sorry, with the survivorship deed, the surviving spouse can then sell the house because it is not a probate asset and she's the 100% owner. The surviving spouse can refinance the mortgage because she's now the 100% owner. Also can take out a home equity line of credit and can call the mortgage bank and get answers because she's now the 100% owner, which she may not have been any kind of owner before. So if you don't have a survivorship agreement, you might not be able to do any of the above. Some things to consider. The survivorship agreement deed is just the first step in opting out of Texas's default estate plan for you. We talked about all the comprehensive options earlier. Think of doing a survivorship agreement deed as just putting a down payment on securing your financial future. You'll see why in a second. The previously explained scenario is only the most chaotic scenario that can unfold. Any married couple can avoid probate court with this legal tool. And this provides for immediate ownership rights to the surviving spouse upon death, which opens up a world of options between being able to get insurance, a new loan, just to get somebody to talk to them as an owner. Our survivorship deed process, if you'd like to get your deed fixed, attending the webinar workshop, which we're doing now, signing the engagement agreement, and then we draft your survivorship agreement deed, and then we have you come into the office for a consultation and signing meeting. And that's a good time to point this out, that this isn't just a document that's going to be delivered over email. You're going to get a 30-minute consultation with me when you come in to sign. You might ask yourself, why should I do this now? I've made it this far. Well, probate is expensive, public, and time-consuming. Do your future self a favor and fix this problem now. This fixes a problem with all home purchases in Texas if you're a married couple. Even if you have a will for the both of you, this saves you $5,000. And this allows you to somewhat defer your full estate planning until later. And you'll receive, for anything you spend on the survivorship agreement deed here, you're going to get a dollar-for-dollar credit towards any future estate planning package with our office. And that offer is good for whenever you do it down the line and for whatever package you pick. Here's my virtual business card. You can see all my information there. And you might be wondering, how much is it if I just want to do the survivorship agreement deed? My normal price for doing these is $650. That includes all of the filing fees and everything associated with it as a flat fee. That includes doing the Texas compliant survivorship agreement deed and a 30-minute consultation where you'll sit down with me for the signing ceremony, and we'll go over and make sure it's a right fit for you and any other questions you have regarding this. It also includes the expenses for the recording the deed with the county clerk, and that applies for any of the county clerks in Texas, no matter where the property is. And we return to you a file stamped copy of the recorded deed for your records, and we keep a scanned copy up here for our records too, in case you ever need a scanned copy again. But since you waited till the end of the webinar, we're going to knock $100 off, and we will do the survivorship agreement deed for $550. So if you'd like to move forward, scan the QR code right on your screen there to schedule your survivorship deed consultation and signing meeting today. We can do these remotely or in person. If we do them remotely, we'll still do the consultation. We'll still do everything. I'll still monitor the meeting, make sure the document's signed appropriately. If it is done remotely, I will need you to send me the original for recording because I need the original for that. Once you scan the QR code, you're going to see this screen, and you'll see my online virtual business card again. If you look down towards the bottom, you can see book your survivor deed appointment or book your estate planning appointment. Tap either of those items and it will take you to my online calendar where you can get on my calendar and be seeing me soon. I want to thank everybody for listening so attentively. And if you have any questions, please feel free to visit my website and chat in. I'm the one that answers it, or text in to our phone line. Either myself or one of my paralegals will answer. Thank you very much, and I look forward to hearing from you, and have a nice day.